Mr. Troupis, the decision by the Wisconsin Supreme Court obviously went against you, maybe not totally against you. I did read the rather scathing dissent from the chief judge. Can you just describe exactly what, in summary fashion, what the Wisconsin Supreme Court's decision was based on your lawsuit, talking about all the areas that you have concern with?
Certainly. So the Wisconsin Supreme Court was urged by the Biden campaign not to address any substantive issues. And that's exactly what happened. The Biden campaign argued to the court that we're not going to talk about any of the substantive things. We're not even going to dispute the things I just brought up to you. But instead, you just shouldn't hear them because a state agency, the Wisconsin Election Commission, had authorized some of these activities. And candidly, as Chief Justice Rogansack and other dissenters held, one, the claims are substantive, they are substantial, and they needed to be addressed. Second, the Wisconsin Election Commission is a bureaucratic organization explicitly that the same court just 4 months ago said has no meaning. It is not law. It is some advice given, and that the statute should control. We were disappointed, not so much in the decision, but in the fact that the decision itself is premised not on an analysis of the law, nor the analysis of the claims. It's an idea that we should not have a transparent system, that you're not going to address these things. And that's what they argued. So it's disappointing, especially in Wisconsin. And Senator Johnson, as you know, we have a long history in Wisconsin, unlike other states, unlike other states, of high transparency. Our recounts were conducted with utmost integrity by both Milwaukee and Dane County, with thousands of volunteers able to look at those items. And it's really a sad day, frankly, when the opposition doesn't argue we're wrong. It argues we shouldn't be heard. That's a strange thing in a state that is so transparent as ours.
Just real quick, I know former Director Krebs talked about the men and women who run these elections. I had about at least a half-hour phone conversation with the county clerk of my town of Oshkosh voting precinct and gave me all kinds of good information. I will tell you, if every county clerk ran their elections like Jeanette Mertens does, we'd have a completely secure election. So I think that's true of the vast majority of elections in different precincts. Mr. Binnall, Mr. Troupis is talking about the law that he was arguing before the Wisconsin Supreme Court was basically ignored. You had a similar statement that it wasn't that the information that you just presented to the committee, it was never rebutted, it was simply ignored. Can you talk about that?
Yes, Mr. Chairman. It was extremely disappointing that rather than address our issues and the data that we presented head on, they simply tried to use technicalities and limiting our evidence, limiting the amount of witnesses we could bring forward, saying that we couldn't introduce any live testimony, but only 15 depositions, only use 15 depositions to show 130,000 instances of voter fraud. And then when it went to the Supreme Court of Nevada, they gave us 2 hours to brief the issues before immediately coming down with a decision. A record was over 8,000 pages long. We were never fully considered by those courts. They never took a good hard list at hard evidence.
I value the paper backups, I value the controls, but they're only as good as they're actually used, and they only provide confidence to the extent that it's a transparent process. So just speak a little bit to what you had access to, what you did not have access to, what you're denied.
Thank you, Mr. Chairman. The very sad fact is that we were denied access to almost anything meaningful that would allow us to verify.
Can you be specific?
Absolutely, Senator. Let's talk about the paper backups on the electronic machines. We were denied any access to those except from one machine in the entire state of Nevada. We were denied that access. That I wish I could have quoted Mr. Krebs when we were fighting our discovery fights at the, in Nevada, saying how important it was to get access to these. We couldn't see any paper backups, and on top of that, the printers on the machine were malfunctioning at such a high rate. We doubt that the paper backups were actually giving us anything of use anyhow. So these paper backups that are supposed to provide such transparency, we couldn't use them. We couldn't see them. We couldn't use they provided us zero transparency at all, except in one machine in the entire state of Nevada. Another example is the fact that we were denied any meaningful discovery in the case in order to go and examine the full extent of the voter fraud. For instance, even when we were able to subpoena the records that led us to discover those 4,000 non-citizens who voted, we couldn't put that into evidence because we didn't get them until the end of the discovery period. And then the court said, well, at that point, it's too late. Our discovery period was essentially 3 days. And we were denied any meaningful opportunity to even use in our case the information that we got. And the court didn't even consider those things, unfortunately. We were denied, we tried to be able to understand the code of these machines, to be able to find out, for instance, as the chairman pointed out, whether machines were hooked up to the internet, whether any of that happened, be able to do a forensic review. We brought forensic experts all the way to Nevada, people that could have discovered this information, people that could have told us what happened with these machines, and we weren't allowed near them. We weren't allowed any forensic audit of it. Nothing that could have given us any transparency, because transparency is not political. That's what we've talked about here. That's what we were denied in Nevada, is any attempt to actually find out what happened. Here's the troubling thing, is one of the reasons that they said that we couldn't get transparency on this machine is because they're proprietary. The information, the coding was proprietary. But we're talking about the countings of votes for the office of President of the United States, and they're not going to let us see the code for how they actually coded the votes? You got to pick one. It's either open source, and we exactly know the way that these machines are counting the votes, or you have to go back to a verifiable system to make sure that the results that are being reported are the results that we get from actual voters, because that is where democracy breaks down. That is really the fear that we have of losing democracy, is when it's not the people's votes that are being counted, but fraud that's being counted. And we can't just pretend that the emperor has any clothes if he doesn't. We can't pretend that we have a clean election when there's evidence to the contrary. And the way that we get that is through transparency. And we were denied that in Nevada at every single turn. We had a clerk who, a registrar of voters, who literally dodged our subpoenas. We had the holiday weekend over Thanksgiving in order to serve subpoenas. They locked the doors of the offices. He locked himself in his house. He refused to accept a subpoena. That same registrar of voters, we have a whistleblower that says he was wearing a Biden-Harris pen to inspect voter sites. This isn't something where we're trying to attack officials. We're trying to say that we have to make sure that it's nonpartisan, that we have to make sure that there's transparency, and you can't deny transparency at every turn.